If you are the brother or sister of someone who's died as a result of wrongful death, can you bring a lawsuit for your own pain and suffering under Maryland law? What do you think? I'm going to put a timer up on the screen, give you a few minutes to think about the answer. Well, unfortunately, the answer is no. Under Maryland law, brothers and sisters cannot bring a lawsuit for their own grief over the loss of their loved one. Why? Well, each state is different, but under Maryland law, only certain blood relatives can bring a wrongful death lawsuit. And those include the parents of the deceased, the children of the deceased, and the spouse of the deceased. And if none of these exist, then unfortunately, a brother or sister can't bring a lawsuit for their own pain and suffering over the loss of their brother or sister. However, don't despair. It doesn't mean that you can't be involved in the case at all, because even though you can't bring the part of the wrongful death, there's actually two cases in a wrongful death lawsuit. The first case is what we call the survival action, and that's brought by the person who's actually been killed by medical malpractice, and that's called a survival action. And that has to be brought by the deceased estate. And that has to then be brought by the personal representative of the estate. And that can be your brother or sister. So even though you may not be able to participate in the wrongful death case, you can still be helpful by being a personal representative in the survival case of wrongful death.